Hello everybody. We shall be starting with the rest part of Parliament. We are continuing with Union Legislature. In the last session, we had done discussion on various motions, and some motions are left. We shall complete the motions first, and then we shall come to the legislative procedures adopted in the Parliament. Okay, we had discussed last class the confidence motion and no confidence motion. The confidence motions are issued moved by the opposition party to let themselves know or be aware whether the ruling party has the confidence of the majority of members or not. So that's why the confidence motion is issued, and I told you that the base of the motion is found in Article 120, Article 75 75 clause 3. So if the confidence motion is defeated, no confidence motion is approved by Parliament, then the opposition has to go. The opposition has to go, and either the ruling party has to go, and the president may dissolve the Lok Sabha or find any alternative to continue the government. So, but likewise, the no confidence motion, there is also confidence motion may be moved by the ruling party because in the coalition there is a fractured voting. There is sometimes there is no single party dominance in the Parliament, and a lot of political parties coming together and form a coalition and make the government. So there is every time a threat to the coalition government. So sometimes if the majority party or the major constituents of coalition wants to establish or wants to ensure itself whether it has the confidence of the majority of the constituents or not, then it may move a confidence motion. So both are related to the majority of the ruling party. Now we shall come to other motions that we have that are very important also. So we shall now come to motion of thanks. Next we shall come to censure motion. Censure motions are that is moved in either house. Censure motion can be moved in either house, and it is on specific grounds or grounds. Specific ground or grounds. It can be moved against. It can be moved against a minister or ministers, several ministers at a time also. The basic objective of this motion is to criticize censuring the council for specific policies. It's criticizing, or the major objective is criticizing or censuring ministers for specific policies and actions It is not voted. It is not voted. If it is approved, the government does not dissolve. So you can see it now that if the censure motion does not, or if it is approved, there is no impact on the government. There is no effect on the government, unlike the no confidence motion. And no confidence motion may not have any specific reason or any specific issue on basis, but censure motion must have a base, must have a reason to be introduced. And if the move is passed, if the motion is passed, there is no effect on the government, survival of the government. It doesn't lead to the resignation of the government, but in this motion the opposition or the members expresses their viewpoints or their reservations against government arbitrariness or government's lapse or government's any ministry lapses or any mistakes, any blunders, any type of irregularities that may have been committed by the minister or ministers. Okay, so this is your censure motion. So there is often a you can say there is often a question to distinguish between no confidence motion and your censure motion of the parliament. You can better decide, you can better write what are the distinction, what are the differences between no confidence motion and your censure motion. Now we shall come to motion of thanks. Motion of thanks. So motion of thanks. Motion of thanks is moved on address of the president, presidential address. That is under Article 87, the President has the right or power to address both the joint sitting of both the houses. On two occasions, especially on the beginning of first meeting of the Lok Sabha after general election, and also at the beginning of first session of Lok Sabha every year. So President addresses the members of Parliament jointly, and in his speech, which is called presidential speech, the President makes the member aware about the government policies, government mode of action or modus operandi of the government, and the future plan and the emphasis the government on welfare administration and the development of the country. And after the President concludes his speech, the Parliament or the House of the houses of the Parliament come to go to the extent that decide to welcome or moves a motion to welcome or to give thanks to the President, and hence it is called motion of thanks. So this motion is moved in the houses of Parliament to give thanks to the President for his address to Parliament, either at the beginning of the first session of Lok Sabha after general election, or at the beginning of first session of every year in that phase. So the non-approval or the defeat of motion of thanks, defeat of this motion may lead to the fall of the government. Because this is also moved by the ruling party, and president belongs to the ruling party, or the president belongs to the head of the government. If the presidential speech is not supported by the majority of the government, in majority of the members in the parliament, it means that the ruling party does not have the confidence of the majority of members in the Lok Sabha, in the Lok Sabha. Therefore, these motions are very, very important, and the motion must be passed in the House, otherwise it amounts to the defeat of the government. The inaugural speech of the President is an occasion available to the members of Parliament to criticize or to decide, to raise discussion and debate, to examine and criticize the government and administration for their lapses and failures. So what I was telling you, that this is also a kind of motions that may bring the government to the ground, may result in the dissolution of the government or in the end of the government. Okay, next we shall move to, that is not no day yet renamed a motion. Okay. So, so that is the called no day yet, no day yet named motion. This is a motion which has been moved, but the date of discussion has not been selected by the Speaker. And the Speaker of Lok Sabha, after consulting the state of business in the House, or in consultation with the leader of the House, or on the recommendation of Business Advisory Committee, decides the date for discussion, and accordingly the motion is discussed. Okay, that is also a kind of things. So there are various, then point of order is another motion, is there point of order. Point of order. Point of order is a motion that is raised by a member if he feels that the House do not follow the normal rules of procedure. A point of order should relate to the interpretation or the enforcement of the rules of the House or such articles of the Constitution related to the proceedings of the legislature. If at any time a member feels that the House is not being carried on in accordance with the rules of procedure, or is violating the Constitution or constitutional provisions in the proceedings of the House, then that may be raised. So this motion is related to interpretation of the rules of procedure and the constitutional provisions related to the proceedings of the House. Okay. So it is usually raised by an opposition member in order to control the government. It is an extraordinary House device. It is suspends the proceedings before the House. No debate is allowed on a point of order. Okay, no debate is allowed on a point. So these are the kind of motions that we have discussed in the last class. And you know that motions are nothing but regulatory in nature, and it controls the government and it awares the government regarding its lapses, regarding its defects, and that is mismanagement, everything can be brought to the fore of the parliament through motion. So motion is an extraordinary device to control the executive, and it is a viable, or you can say it is a constructive weapon in the hand of the legislature to have control over the executive. Okay. So these are the motions we have discussed. Now we shall come to the legislative procedures. Legislative procedures in parliament, perhaps we have not discussed it. So legislative procedures. Legislative procedures in parliament we shall discuss today in a new segment of Indian parliament. Legislative procedure, which is almost very significant aspect of that. Before that, let me tell you that apart from the motions, there are certain resolutions also passed by the House. There are private members' resolutions, there are government resolutions, there are statutory resolutions, and the government private resolution is moved by a private member. It is discussed on alternate Friday and in the afternoon sitting. And the government resolution can be moved from Monday to Thursday, and they are great in number. And there are statutory resolution which can be moved by the minister or a member, and it is related to a specific statute or act. So resolutions are there also. Okay. Now we shall come to legislative procedure. As all of you know, making legislation or drafting a bill or passing a bill is a fundamental role of parliament to play, because parliament is nothing but union legislature, and union legislature or the Parliament of India has adopted a specific procedure for the passage of bills, and this is what the parliament is all about. Its major function is to prepare or to make legislation. The parliament can make legislation for the entire country, first of all. Not a single part of the country is left out of the purview of parliament, or out of the power of territorial power of the parliament. So parliament has authority over the entire geographical territory of India with regards to legislation. Another thing, parliament can make exclusive authority over law-making authority over union list, and all the subjects in the union list are under the direct control of the direct domain of the parliament, and it has the exclusive authority. Parliament can also make legislation on concurrent list. So basically parliament's legislation power or legislative powers are extended to union list and concurrent list. Apart from union list and concurrent list, the parliament can also make legislation for the state list in certain circumstances, such as during national emergency under Article 250, and there are also when the Rajya Sabha passes a resolution to this effect. If Rajya Sabha passes a resolution that it is essential to make a law on the state subjects for the larger interest of several states, then parliament can make a law, and when the states make request, that is probably 251, and when during the national emergency and during while implementing international treaties and obligations also, the parliament can make legislation on the state list. So we can say parliament not only makes law on the union list and concurrent list, but also on state list in certain circumstances, exceptional circumstances. So parliament's law making power is more widespread, more vibrant, and more extensive than those of the state legislatures. Another thing, the law-making power of the parliament is supreme. So, its law-making power on the concurrent list is shared by the states also. But in case there is a union law or and a state law over a specific matter in the concurrent list, and in case there is a conflict between the two, the state list and the union list, then union law and state law, then the union law prevails over the state. Although the Supreme Court has evolved a couple of doctrines with regards to this conflict, but still the legislative law or the parliamentary legislation has a upper hand or has a superior position in comparison to the state legislation. Okay, so these are the things that the parliament has to do, and parliament has not only the legislative power to making law making power. It doesn't not only makes law or passes law, but also amends law and repeals law and also brings changes in the law. So parliament not only makes legislation but also amends a legislation, repeals a legislation, and does any change in the legislation. And how does it do? It does the changes, or it makes law through four different kinds of bills. So there are on the basis of the content of the bill, there are four kinds of bills, and on the basis of introduction of the bills, there are two kinds of bills. So if you analyze this on the basis of introduction, of the bill, it is one is a public bill or government bill, public bill. Number two, private member bill. So on the basis of introduction, you can notice that there are two kinds of bills. One is public bill, which is introduced by a minister, only by a minister, not a member. A private member bill introduced by a member of parliament only. So not a minister. So when a bill is introduced by a member who is not a minister, it is called private member's bill, and a bill which is moved by a minister, it is called a public bill. Most of the bills are public bills, but there are certain kind of private members bills also, and in parliament you will see a committee on private members bills. That committee enlists the number of bills introduced, private members bills introduced in the parliament, and also monitors its status or its implementations, or monitor its passage in the House. So there is a specific committee allotted to that purpose. So that means a minister, not only a minister, but every member of parliament can introduce a bill, because all of them are lawmakers. All of them are lawmakers of the country, and they constitute the largest fraternity of lawmakers, parliament. Next is on the basis of the content of the bill. Bills are of two types. So types of bills. There are four types of bills. One is ordinary bill. Number two, money bill. Number three, finance bill. Constitutional Amendment Bill. So look at the 4 types of bills that are there. Okay, so you can see that there are certain kind of bills like ordinary bill, money bill, finance bill, and constitutional amendment bill. The constitution provides for the passage details about the passage of the bills in the parliament. So we shall discuss one by one and see what is the difference between their content and passage, mode of passage. First we shall discuss ordinary bills. Why they are called ordinary bills? What is the reason they are called ordinary bills? Because they do not contain any financial matters. They are least concerned about financial matters. They do not highlight the financial matters. They are related to other laws or other provisions, not financial provisions. So when a bill does not connect or does not relate itself to monetary matters or financial matter, is called ordinary bill. So ordinary bills are exclusively so called because these bills are not related to monetary or financial matters, these bills are related to the monetary and financial matter are not related, better write are not related. They can be introduced in either house. That means an ordinary bill can be introduced in either Lok Sabha or Rajya Sabha. There is no restrictions. They can be introduced either by a minister or a member. That means ordinary bill can also be a private member bill. It requires simple majority of the confidence of the House, and it passes through three stages. Can you take a note of this? Okay. So you have seen You have seen that these bills are introduced in either house, and they can be either introduced by a member or a minister. It passes through 3 stages. Okay? So, stages of bills. It passes through 3 stages such as first reading, number 2, second reading, and number 3, third reading. The stages of the bill are called readings. And in the first reading you will find the different stages in the life of the bill. And remember, each bill has to pass these stages in each house individually, separately. And after the bill is passed, after the third reading, it moves to the second house or the other house, and the other house discusses the bill, passes it or moves it through stages. So let us see what are the different things that takes place at first reading. So in first reading, the bill is introduced in the house. The member or the minister who introduces the bill seeks the leave of the house or the permission of the house. And after the permission, the bill is introduced by the member, and he reads by the member or a minister, and who reads the title and tells about the objective of the bill briefly. Later, the bill is published in the Gazette of India for knowledge and information of others. But if the bill is published before its introduction in the house, there is no need to seek the leave of the house for introduction. So in a nutshell, we can say there are 2 things takes place in first reading. Gote la introduction of the bill, that is introduction of the bill. Then number 2, publication of the bill. In either house of parliament. Okay, so just a minute. Okay, so publication of the bill in either house. Publication of the bill in the in the Gazette of India. Okay, so this is called first reading. Next is second reading of the bill. This is one of the vital stage in the life of a bill. In this stage, discussion and deliberation on the bill are allowed, and the bill receives completely a complete shape or final shape, and there is seldom any change in the bill latter. So second reading is a very crucial stage in the life of the bill or in the passage of the bill. During this time, the bill gets its final shape, almost final shape. And the second reading can be considered, can be divided into different parts like general discussion of the bill, and general discussion of the bill, and number 2, scrutiny by committees. We shall discuss first along the stages. Then number 3, consideration stage. And joint committee may circulate the bill. Okay, so stage of general discussion, committee stage and consideration stage. These are the 3 important stages of the government, of the bill in the second stage. In the general discussion, the discussion takes place at length. All the members are required to discuss the bill in principle and provisions are discussed generally. Okay, after discussion, the bill may be referred to a select committee, and select committee either select committee or joint select committee. So the bill may be referred to the select committee and joint executive, which closely scrutinizes the aspects of the bill. Then the consideration stage, and in this stage the bill, the amendments or the discussion on the changes in the bills are carried on, and whatever changes take place in this bill, it takes place in this stage only. So consideration stage is very important also, because on this constitutional page, on this consideration sides, the bill and each aspect of the bill is considered and put to be voted. So in this way, the bill is completely scrutinized and edited and finalized. So second reading finalizes the shape of the bill, and there is nothing left to the third stage. In the third reading, if you ask me, if you third reading, then in third reading the legislative the bill, in the third reading the bill only receives the assent or the consent of the House or rejection of the House. I mean, in third reading, it is the final stage of the bill in the Parliament, and in the third reading there is acceptance of the bill, or number 2, rejection of the bill. So the bill is either accepted by the House and may be rejected. In case of rejection of the bill comes to an end and there is no alternative, there is nothing can happen because the other house has not seen it. So the bill will come to an end. But in case the bill is accepted, In case the bill is accepted, it is sent to the second house. Here second house may be Lok Sabha or Rajya Sabha. So options with second house, options left with the second house. What are the options left with the second house? When a bill passed by Lok Sabha, it goes to Rajya Sabha, or when a bill is passed by Rajya Sabha, it goes to Lok Sabha. So what are the options left with the house which receives a passed bill or a bill half enacted by the other house? First of all, it may pass the bill as it is. It may pass the bill as it is and then it goes to the President for his assent. Number 2, it may withhold its assent. Withhold its assent. Number 3, it may return the bill for reconsideration of the House. Number 4, it may not have taken any action on the bill so far. On the bill for a period of 6 months or more, or less, 6 months or less. So there are 4 options left with the second house. It may pass the bill as it is. I mean, it may not bring any amendment, it may pass the bill as it is. Then it may withhold its assent, may reject its assent. And what happens when the house one bill is passed by one house and rejected by the other? There is a prospect of joint sitting. There is a prospect of joint sitting that we have discussed. Then it may return the bill for the reconsideration of the House. And if the House finds the reconsideration inappropriate or not feasible, and if the House is convinced that the bill has already been debated, discussed, and every care has been taken to provide a correct bill or as a responsible legislation. So that is why the bill that's the Parliament, the President can return to the Parliament for reconsideration if the President doubts the true intent of the bill. But President can send the bill for once only, not for several chances. So it was provided by 44th Amendment Act 1978 that President shall not return a bill more than once. So whatever, but it may return the bill for the reconsideration of the House. Sorry, just a minute, I will, it may, you can say, it may bring amendments to the bill, amendments in the bill, and return the bill for the reconsideration of the House, of the second House, of the first House. So if the second House brings any amendment, any change, then it can send it back to the first House for its reconsideration. If the first House agrees with the amendment suggested by the second House, there is no problem, it will be passed and goes to the President for his assent. But if the second House does not agree with the amendments, first House does not agree with the amendments suggested by the second House, then it will result in a deadlock of Parliament, and that can be resolved through joint sitting. Another thing you have to remember that money bill is not returned. There is no bill or suspensive veto. We have discussed there is no suspensive veto over the money bill. Money bill cannot be returned by the House. If it is returned by Rajya Sabha with or without amendments, it will not matter because Rajya Sabha has very negligible authority over the money bills. Then it may not have taken any action for say. If a bill after receipt by one House, if 6 months lapses and no action has been taken by the House on that particular bill, then the bill then the bill will come to that will stay there. So in these three cases especially, when a bill passed by one House rejected by the other, when the bill returned by the first House with amendments, but the first House does not agree, and if 6 months lapses after a bill has been received by the first House and no action has been taken. So in these 2, 3, 4 circumstances, the President may summon joint sitting and to resolution of the mechanism. There has been many joint sittings we have discussed. There has been more than a couple of joint sittings since the commencement of the Constitution. So that is the rationale of options left to it, the second House. And after the passage in the second House, it goes to the Governor, it goes to the President. It goes to the President for his assent and it becomes a law. So these are the procedures of ordinary bills carried on through simple procedure majority method, and it takes place. So it is all about your ordinary bill. Kindly take a note of this. Okay, so these are the things, and if the bill is passed by the second House, it goes to the President, and you know what options are left with the President, that we call veto powers of the President. So that is another part of the things. We have already discussed the veto powers of the President in the presidential chapter. You can relate this chapter to this. So ordinary bills are passed by either House of Parliament, and you can see that both Lok Sabha and Rajya Sabha has equal power, equal privileges over the ordinary bill. There is no superior and inferior relationship between the two houses over an ordinary bill. Next we shall come to money bill. The money bill is confined under Article 110. Article 110 contains the details of money bill, what constitutes a money bill. So we shall make a note of that. First of all, the money bill is certified by the Speaker of Lok Sabha, it must be introduced by a minister only. Minister only. Can you take a note of this? Okay, a bill is said to be a money bill if it contains any one of the following procedures. Of the following provisions. Number one, alteration, abolition, and merger or you can say alteration, abolition, imposition, remission, alteration or regulation of any tax. Number two, the regulation of borrowings by kindly take a note of this. Okay. Number 3, the custody of Consolidated Fund of India and contingency fund of India. I mean the money withdrawn from the consolidated fund, from these funds, and deposits made into these funds. Next, number 4, the appropriation of money out of the Consolidated Fund of India, Consolidated Fund. Next, declaration of any expenditure as charged this is charge expenditure on the Consolidated Fund of India. Kindly take a note of this. Okay. So these are the number 5. The number 5. Then any matter decided by the President to be a money matter and to be declared as a money bill, that will be done also. But the imposition and alteration of fines and pecuniary penalties and also fees of license, fees for services rendered, and imposition and abolition and alteration of any tax by local authority do not form the definition of money bills. That is only tax but not fees and any financial or pecuniary penalties, that does not include. Next is procedure. Unlike ordinary bills, money bill can be introduced only in Lok Sabha first. It is that the money bills can be passed only by, that can be introduced only by Lok Sabha, in the Lok Sabha, and it can be introduced only by a minister, not a member. So money bill cannot be a private member's bill. It cannot be a private member's bill at any cost. So that is to be, it is always a public bill and it should be introduced by a minister only. Money bill is broadly discussed in Lok Sabha and passed in simple majority of members present and voting. Then it goes to Rajya Sabha and Rajya Sabha doesn't have the power to amend or reject a money bill. It can only recommend, and such recommendations may or may not be accepted by Lok Sabha. And Rajya Sabha can retain the money bill for a maximum period of 14 days. At the end of 14 days or the lapse of 14 days, the bill will be declared to have been passed by the parliament. So first of all, we shall write ki money bill requires prior recommendation of prior recommendations of the president. It is always a public bill and should be introduced by a minister. Introduced by a minister. It is passed through simple majority of the members present and voting. So kindly take your things. Okay. Then Rajya Sabha doesn't have the power to amend or reject a money bill. It can make recommendations only. Rajya Sabha can retain a money bill for a maximum period of 6 months. Number 5, at the lapse of 14 days, the bill is deemed to have been passed by okay. And another thing you can add, another thing we can add also, that there cannot be a joint sitting over a money bill in case there is disagreement, or you can say deadlock, between the two houses over it. So what I mean to say, there is no joint sitting between the two. There is no joint sitting between the two in case there is an agreement takes place, a disagreement takes place between the two houses over the bill. So unlike ordinary bill, money bill is not to be resolved through joint sitting, and as such the prospect of disagreement over a money bill is very negligible, because the Rajya Sabha is deprived of its substantial powers so over the money bill. So there is no space, or there is no space for any type of things. Sorry. Okay. So there is no specific provision like joint sitting or anything, and obvious because Lok Sabha has prerogative role to play in case of money bill. So Rajya Sabha has very negligible role. It cannot make any amendments or cannot reject the money bill. It can only recommend, and such recommendations may or may not be acceptable to the Lok Sabha. Another thing, it can retain a money bill for 14 days, and at the end of the 14 days or after the lapse of 14 days, the bill will be deemed to have been passed by the two houses. So you can see that Rajya Sabha is devoid of any substantial power in case of the passage of our money bills. It is totally left to the discretion of the Lok Sabha and to the supremacy of Lok Sabha, because executive is responsible to Lok Sabha, and in money matters Rajya Sabha's delaying nature is kept out of the purview. Another bill, that is Finance Bill 1 and Finance Bill 2. In case of Finance Bill 1, or Finance Bill 2, there is some differences. Finance Bill 1, Article 1171. Finance Bill 1 is like it deals with a bill which deals with financial matters, but not covered under Article 110. That means not covered under the definition of money bills are called financial bills. So finance bills are you can say the finance bills are like the revenue generation aspects or income aspects of the bills, and certain changes in the taxation and others also. The bill that carries revenue generation also. So they are termed as Finance Bill 1 and Finance Bill 1 or 2, whatever may be. Finance Bill 1 is little bit the same as the money bill, because like money bill, Finance Bill 1 should be introduced in Lok Sabha, and it requires the prior recommendation of the President. But in other cases, latter, it is the same as the ordinary bill. So Finance Bill 1 is similar to money bill in two aspects. One is that like money bill, the Finance Bill 1 must be introduced in Lok Sabha first. And another thing, like the money bill, the Finance Bill 1 also requires the prior approval of the President before its introduction. But in other cases like approach of Rajya Sabha towards money bill, Finance Bill and others, it is the same as the ordinary bill. So Rajya Sabha has power to amend or reject a finance bill. It can also treat the bill with like an ordinary bills. And in case there is a deadlock between the two houses over the Finance Bill 1 or 2, the President can summon a joint sitting. In case of Finance Bill 2, we can say that it is the very similar, it is exactly the same procedure followed for Finance Bill 2 as we follow it in case of ordinary bills. So Finance Bill 2 is nothing but an ordinary bill, because it neither requires the support of the Lok Sabha, neither requires its introduction in the Lok Sabha first, nor does it require the prior approval of the President. Okay, so these are the bills that we can conclude. The bills. So Finance Bill 1, 2. And we have examined Finance Bill 1 and 2, both of them are like ordinary bills, but Finance Bill 1 is somewhat similar to the money bills in two respects. I have already discussed these provisions. Okay, now CAP, Constitutional Amendment Bill. A constitutional amendment bill, a constitutional amendment bill is a type of bill. You can say a constitutional amendment bill is a bill which can be introduced by the parliament to amend the constitution. But you know the constitution can be amended by simple and also by special majority. But the constitutional amendment bills that we are going to discuss is a special majority amendment, otherwise called what? Constitutional amendment bills. So a constitutional amendment bill is just passed by the parliament alone, because parliament is in the single constitution country, parliament is the sole authority to bring any amendment in the constitution. So a constitutional amendment bill under Article 368 can be introduced in either house of parliament, That is also a point to be remembered. And so there are certain types of amendments we can see that by simple majority, by special majority, through the ratification of the states. So certain provisions are there also that can be provided in the constitution, which will be amended not only by the parliament but also by the two houses, okay, by the state legislature also. So a constitutional CAB can be introduced in either house of parliament Number two, it does not require the prior approval of the president it can be introduced by a minister or a member. Kindly take a note of this. Okay, a minister on or a member, or it can be a private member bill or a government bill, president's bill. Then next, each house must pass the bill separately each house must pass the bill separately. Pass the bill separately. There is no provision of joint sitting in case of disagreement between the two houses over the bill. Some constitutional amendment bills affecting the federal character of India, of the Indian Constitution, must also be ratified by at least half of the states. Kindly take a note of this. There are certain matters which related to the federal aspects of the Constitution, or any change in the center-state relation, any change in the implementation of the DPSP, or election of the president, organization of high court, jurisdiction of high courts. All these things must be ratified by the state legislatures, although they are passed by the parliament and parliament introduces it. But towards the end of the bill must come to the states, and half of the states must approve the bill, otherwise it cannot become an act. So we can say this is the amending power of the state legislature, but remember, the state legislature are not the authority to amend the constitution or to initiate the amendment bill in the parliament, or they cannot do anything. Next, the president has been made bound to assent a cap, is bound to assent a cap, that is by 24th Constitutional Amendment Act 1971. The President is bound to assent the bill upon the arrival of the bill with him. He cannot withhold his assent, he can return the bill, he cannot put off his assent, rather he has to give assent by, it has been made binding upon him by 24th Constitutional Amendment Act 1971. So in this way, the constitutional amendment bill are introduced And constitutional amendment bills are very important. They are very important bills because they change the things. So as of now, the constitution can be amended. Constitution can be amended by parliament, both by simple and special majority, without destroying the basic structure. So the amending power of the parliament has been made limited. It is not absolute authority to amend the constitution, or it cannot change the constitution arbitrarily. Rather, it can change or bring positive changes to the constitution without diluting the without diluting the basic structure of the constitution. Without diluting the basic structure of the constitution. Okay, so this is all about your bills, like things, the type of bills, and we have discussed there are 4 types of bills in the parliament, and we have discussed them in briefly, how the bills are passed, and this is called legislative procedure of the states. Now we shall put options of funds in parliament, funds. We shall discuss about consolidated fund first. Consolidated Fund of India. Fund of India. It Article 266 mentioned achi. It's kept under the custody of the Parliament of India. Parliament of India. So contains all revenues generated by received by the Government of India, received by Government of India. Number 2, loans raised by Government of India, and all money received in repayment of loans. Number 3, repayment of loans. Repayment of loans or others is etc. To Government of India. So consolidated fund is the largest fund under the largest ever fund, and under this fund all the tax and non-tax revenues are deposited, and it is kept at the custody of the Parliament. No money can be sanctioned from the Consolidated Fund of India without the prior recommendation of the President and without authority of law. So the budget and money bills, the other bills, the money bills are passed by Parliament to draw money from the Consolidated Fund of India. So Consolidated Fund is under the direct supervision of the Parliament, and this is one of the aspects of financial control of the Parliament over executive. Okay, so that is called your Consolidated Fund of India. Now we can discuss that public account of India. That is 266, Article 266(2). It contains all public money other than those credited to the Consolidated Fund of India Consolidated Fund of India. It is like PF deposits of the people, savings bank deposits, judicial deposits, and others also, departmental deposits, remittances, etc. And this money belongs to the people of India, belongs to the people or the party, other persons. It does not belong to the government solely. So government does not usually draw money from this fund for expenditure. Rather it acts as a banker in this bank, in this fund, and gives loan to this bank. So in this fund, the government acts as a banker, mostly in banking transactions nature, public account. It is operated by executive action. It is operated by executive action, but consolidated is operated by parliamentary action. It is operated by executive action. Kindly take a note of this. Well, so this is one of the running fund and it is under the executive action, not under legislative action. Then your last but contingency fund of India. Article 267. The Constitution authorized the Parliament to establish a contingency fund of India in which amounts determined in law are paid from time to time, and to enable the executive to meet unforeseen expenditures and in the absence of the Parliament. So that is in the absence of Parliament. This fund enables the executive to meet unforeseen expenses. It is established, operated under Contingency Fund Act, Fund of India Act, (1950). The amount kept in this fund is decided by the Parliament from time to time. It is kept under the disposal of President. It is held by Finance Secretary on behalf of the President. Finance Secretary on behalf of the President. The corpus is rupees 30,000 crore. Rupees 30,000 crore is always there in the corpus, in the contingency fund. The fund has been raised by this government in 2021. So initially it was 50 crore and it increased to 500 crore probably in 1997, and later in the latest time it has been increased to 30,000 crore by the government. And the money can be advanced from this fund by the President pending the approval of the Parliament. So this fund is also run by executive action. Only consolidated fund is run by the legislative action, and these two funds, public account and your contingency funds, are operated by executive action, because there is nothing for Parliament to deal with all these things. Okay. So this is how the financial control or financial arrangement have been made in the country. And remember, consolidated fund, that is the one of the most active and you can say the live active fund of India is under the custody of Parliament, and other two funds are not under the custody of Parliament, they are run by the executive actions. Okay. So today we have finished some important aspects of Parliament, and there is only one aspect remain, committees, and then budget. We shall also cover budget also for your cognizance, for your reference. I will discuss budget also and other grants for your reference. Okay. So in this class we have discussed until consolidated contingency fund and public accounts. In the next class we shall be discussing the committees in Parliament and also the budget. Then we shall come to multifunctional role of Parliament. Okay. So till then, bid you goodbye, and watch our classes and have your constructive views. I hope all people are getting some benefits from our classes. We are endeavoring to be with you, or to be beside you forever until you write the success story of your own. Thank you very much for having me.